Good afternoon and welcome to our latest in the series of residential conveyancing forums. Sorry, we're a bit late starting, a few technical problems, as is often the case here. But hopefully one of the good things we'll be talking about today is how technology can help you, as we've got Jamie Schmeld from Collaborative Conveyancing to talk about some of the products that they are working on now to try and smooth the conveyancing process. As always, Ian is here to lead the conversation and to give us his knowledge. But again, as always, the important part here is your participation, your knowledge and your experiences are so valuable. So Ian, no more, I'll hand over to you.
Thanks, Robert. Robert, were you at the Bold event yesterday?
I was, yes. It was
good turnout there.
And,
Are there any brownies left?
There are a few left, but they're either going to be eaten by me or thrown out to the birds at home.
All right.
So
okay. I've got a 3D printer, you know. I was hoping you could pop one as an attachment in an email and get it up to me for tea time today. No?
Well, I'll have a go in. Yeah, it's probably doable. Yeah.
Delighted. That's fantastic. Anyway, Robert, thanks very much. And seriously, massive thank you to Stewart Title for sponsoring these events. Apologies for me. Once again, my inability to work tech has been my Achilles heel. But I'm delighted that Jamie's with me. Delighted that Robert's here too. And delighted, of course, with you all attending. Really important to understand and appreciate, as Robert mentioned, the significance of this forum. It's not the Ian Quayle show, thank goodness. It's not the Stewart Title show. It is an event for you in which to share ideas, problems and issues. We have had one question which we'll have a look at as we progress. What I'd like to do is immediately introduce you to Jamie from Collaborative Conveyancing, who's going to have a run through with regard to his product. Chris Harris, Jamie, who's one of your colleagues, I know very well, is a splendid guy, very important sort of player in the field of residential conveyancing. So I'm delighted to introduce Jamie from Collaborative Conveyancing. Jamie, is it all right if I act as your wingman and move the slides for you?
Absolutely.
I promise to try my best. Whether I succeed or not, who knows, but I'll try. So off we go. Jamie, over to you.
Yeah. Hi, everybody. Hope you're very well. So I'm Jamie from Collaborative Conveyancing. I am the head of customer success here. I used to be a conveyancer, so I am very much aware of the bits and pieces and the struggles that some of us have had to contend with over the past few years, certainly post-COVID and post-SDLT. And it was something from my perspective was when Chris Harris came to me to put forward Collaborative Conveyancing and our inquiry manager, was something that I sat down, and I'd left Own Your Patient in August of last year. I was consulting for a panel firm at the time, and Chris brought the opportunity up in front of me. Now, when he showed me inquiry manager in its first iteration of which it was back then, it was very much something that as a conveyancer I'd seen would work quite nicely in the sector, not just for speed but also for helping people structure the way that they do their inquiries. And what we found a lot of, and again it was spoke about a lot yesterday at the Bold Legal Conference, was the lack of education post-COVID and post-SDLT, and we do have a skills shortage in the industry. It came up on 4 or 5 of the keynotes that I sat in yesterday, and that for me is where we're kind of finding that there is a bit of an issue, and we're hoping, and that we can alleviate some log jams based around that. And it does come down to, for us, again, I was sat in there. I was sat on the sort group leveling up forum, and I was sat with a lot of conveyancing firms, and we were talking about a lot of it. And the log jams, 99% of the time, do come from inquiries. If you don't mind flipping the next slide for me, Ian. So again, what we're trying to do is we're trying to commit to making the home buying process more efficient for everybody, not just one party. And I think that's something that a lot of firms have come out and said. That they feel that conveyancers don't do it right, or they have a better way. And to be honest, that's not the view that we take. Conveyancers have an extremely hard job. And people just think, well, you sit there and you do the law side of it. You don't. You also have to deal with your clients. You also have to be a person. You have to be able to be personable with those clients. You have to be transparent with those clients. You also have to speak to the brokers and the agents. And at times, it can become rather overwhelming. And it does create quite a bit of frustration. So what we're trying to say is we're trying to alleviate and make everything more efficient, so everybody has more transparency in the market and their frustrations will come down. And there's nothing worse than on a Thursday morning, you're trying to set all of your completions up for the day before, and you're making sure you've got all your funds in, and you're making sure that everything's ready. And actually, you've then got 3 or 4 estate agents ringing you asking why the inquiries that you dealt with on Monday haven't yet been responded to. And it's kind of like, well, if we do have something from that position, if we do have some transparency, which we can talk about a little bit more shortly, we're hoping that those communications will calm down so you can actually get on with dealing with your job. Next slide for me, Ian. So the goal for us is we want to reduce the time spent working on inquiries. We found, especially on some of the studies that we've looked at recently, and certainly in the forums that I've been sat on in the last month, it is a certainty that there is quite a lot of firms that have got inquiries that are outstanding for many, many, many months. And a lot of the time it is over very small things. And the main cause of that, we found in the studies that we've researched, is lack of people taking a view. And again, that may come down to skills shortage, that may come down to all sorts of different bits, but it's certainly a mainstay of the conversations that I am hearing and being involved in. Is there is quite a lot of files that are outstanding that have two inquiries, maybe one inquiry outstanding on them. And when the higher management go into those files to have a look at them, they're certainly things that can be dealt with quite easily. In terms of bringing confidence to newer in professionals, again, it's just something that we're looking to deal with. It is hard coming into this world. It's a lot harder now than it was a few years ago because there is a lot more pressure, and certainly the expectations of what a conveyancer does is misshaped. I was sat in the Bold Legal Conference yesterday with guys of the TA6. There was quite a ruckus in there, when you've had 2 estate agents on the desk, on the stage, and there was no real sign of them kind of making out to say, are they changing the way that they're going to do things? Are they going to help out in terms of management of their expectations to clients? I recently seen on Rightmove that there was an estate agent claiming they can get things done in 4 weeks. That doesn't help the confidence of any conveyancer, never mind newer conveyancers in the market. And if they're already on the back foot from having expectations lowered to 4 weeks, when realistically we're talking 130, 140 days for completion, realistically, is that going to help the confidence? No, it's not. It's not going to help them. And we just want to try and give them that confidence that actually with Inquiry Manager there is a little bit of help and there is a little bit of support that isn't going to take over. It's going to give them a guidance to help them. And then being more collaborative with the other side, that is something that I think we can all be guilty of. I was certainly guilty of it as a conveyancer, being far too defensive. And I can certainly say I was that defensive conveyancer that would go back and say, I'm not answering that. No, not doing that. Instead of, or even just to the point of what we're looking to do, just sending the original inquiries with my answers underneath. I would never do that. That was not something that I would have done. I would have personally pushed on and just said, no, I'm not doing that. I'll send you my responses. That's it. And it's something that we've designed into the system that will automatically do that for you. So then we can try and shave some time off. So even if the other side isn't using Inquiry Manager, that's fine. We don't mind that. But they will still get their inquiries back, so they're not having to go back through their file. Again, removing the pressures from the third party is something we've already touched on. And that is, we have a reporting tool that you'll be able to send out to your third parties, such as your brokers, your panel managers and things like that, to be able to show them where you're at in terms of the inquiry stage. And it will just be able to help along the way, so you're not being chased 24/7 for updates from them. And then finally, overall, we're looking to reduce the transaction time, which will reduce the costs. The cost to firms right now is extending because the time it takes for a transaction is extending. And a firm looks at it from a point of view of, if a transaction's taking X amount of time, that costs me X. And then if that goes up, the cost goes up because the conveyancers are carrying on working on that file. So all those things are the goals that we're trying to do here at Collaborative. Some of the challenges that we see, again, we've touched on them: skills shortages, transaction times, cost reduction. So again, a big point yesterday in one of the keynotes I was sat in was around pricing and costs that conveyancers charge and the differences between the sectors and all these kind of things. Again, over the few years that I've worked in the system, in the industry, I came into conveyancing when I was 19 years old. I was an estate agent before that. Please don't smite me for that, guys. In the terms of the costs that I've seen, they are certainly being reduced over the years. And certainly in terms of when I was younger as an estate agents' costings are much more effective than what we do inside of our conveyancing. We want to try and help alleviate that cost reduction by bringing the transaction times back down. And again, the parties we've already spoke about, again, the pressures from the other side. So just a quick case study of what we found. So again, I don't know how many of you have seen today's conveyancer release their annual survey. So they released that 3 weeks ago. Their results came in to say that 70% say that voted, of course, that inquiries have increased. Now, again, some people in here might say that's different. Again, it's a survey that was done over a course of 2 weeks. And again, 76% of them are saying that the relevance of those inquiries have decreased. And again, something that I've heard of quite a lot is there is more standard inquiries than ever, and actually property specific inquiries have certainly gone down. Again, average caseloads have increased since in the last 10 years, which I think we can all say it has. And it certainly spiked between COVID and the SDLT. And again, we've seen that in some of the keynotes yesterday at Bold Eagle. Again, between 21 and 23, 12.6%, the drop in number of conveyancers, again, part and parcel of the skills shortage that we have in here. I heard a quote yesterday at Bold Eagle, "We are a rare breed." And that kind of hit me quite hard. And I thought, wow, okay, and I'm not a practicing conveyancer anymore. I am the exact person that after stamp duty, I didn't want to leave the industry. I love this industry. However, I do believe that I am that perfect example. After SDLT, I went to my old boss, and again, please don't smite me for my sins, guys. I did used to work for O'Neill Patient Solicitors, and I went to my old boss and said, "Is there any jobs in O'Neill Patient where I don't have to be a conveyancer anymore?" Luckily for me, there was, hence the reason why I am where I am now. And do I miss conveyancing? Yes. But did I want that pressure again? No. And a little bit around that was, I didn't see my partner for 3 whole weeks at the very end of stamp duty holiday. I never want that again. It was incredibly stressful. I'm still stunned that was not shown on the news more. actually, which was very unfortunate. And again, we can say it again and again and again, the transaction times within that period of 21 and 23, they've increased, and they've increased tenfold. As you can see, 82 days on average it took in 21. We're now looking at 132 days on average, which is far too high. And again, a typical conveyancer running a caseload at the moment is somewhere in the region of around 100 to 200 cases, which is high. It's really, really high. I have ran 150 cases myself. It was hard, and it wasn't easy. And again, most of them are tracking somewhere between 1,000 plus inquiries at any one time. That is extremely difficult. And that brings us into Inquiry Manager. So Inquiry Manager is our tool that we have. It currently works as an add-in to your Outlook. So it is not it's standalone to OneXtream, but it's not a portal. We extract your inquiries from your Outlook. We also take any PDFs, anything like that. So if it's a PDF, a Word document, Excel spreadsheet, for instance, that has inquiries in. And again, I honestly, hand on heart, say I've never seen them in Excel, but I'm sure someone has in this forum. What we can certainly say is it can extract those inquiries through, and it will then read the inquiries for you and put them into a list for you to then deal with. It will also pull through any PDFs, such as contracts, such as water searches, local searches, search maps, conveyances, all these kind of documents it will pull through. And you can then view those as a side panel. So we have a split screen. You'll be able to view your documents on one side and you can answer your inquiries on another. So then you're not having to have 4 or 5 screens open. I'm sure that most people in this room, me included, work with 2 screens. It's fantastic to have 2 screens, it is, but when you're filling up 2 screens, I've been there, it's rather annoying. So if you can have 2 things broken down into one space, so you can have your documents that you need to deal with those inquiries in one section and you can deal with them on the other, perfect. Again, we're not looking to mess around with taking out the conveyancers. It's nothing, we're not trying to replace the conveyancer, which is something I heard shouted out yesterday at one of the tech keynotes. We are looking to give the option to the conveyancer of how they want to deal with their inquiries. So there is multiple ways that you can answer your inquiries inside of Inquiry Manager. You can type your own, so you can completely type your own inquiry reply. That's fine. We also have for the first round, and usually for the first round, this is what you would use anyway. We have quick responses such as confirmed, and one that a lot of people do like is this does not comply with protocol. We also have referred to client, to follow, attached. So there is quicker responses for you, so you're not having to write out the same thing and the same old ditto, ditto, ditto. You can just click and move on, click and move on. There is also something called detailed responses. Now, our detailed responses, and again, please don't smite me, guys, when I use the word AI. AI isn't bad, I promise, as long as it's used correctly. And the way that we're using AI is we're using it in closed AI. So it's our AI, we've built it, it sits within inside of us. We use a company called Azure, which are in the southeast of England. And what it is a knowledge bank that it reads from that is built by our conveyancers. So how we're dealing with that is certainly what we're doing is it reads from our actual database and our data bank. And again, we'll go into a bit more detail about that later on. So what you can then do is you have 3 options. You can write your own, you can use the quick responses, you can use the detailed responses if you wish. And then we have something called multiple actions. Now, again, for some people in this room, this won't apply, but for others it will. And that's what we're trying to do. We're trying to fit it around everybody and everyone's workflow. Everyone has a different workflow. I know that, and I used to have a different workflow to the people that I worked around. Everyone has their way that they want to do things. And we're just trying to make sure that it fits to everybody instead of forcing something to fit you. That's not what we want to do. And again, I've been there when I've had technology pushed on me that made me fit it, not the other way around. We don't want to do that. It is certainly, we want this to fit you. And what multiple responses will do is, A, if you've got a contract that you've been asked to approve and you say amended a contract approved, fine, you can then satisfy that inquiry straight away. It will move into a secondary list that you can still see, but it will give you some visual of letting you see the wood from the trees, seeing what is actually pending and what is actually satisfied. It will break them two down for you. Second step is you can then reply straight to the other side and the client and the third party all in one sitting. So you can say, refer to the client, there's the section for the client, refer to the other side, I've referred it to the client. And if it's a management pack, for instance, you can then request the management pack from the management company. You can do all that in one sitting, so you're not having to have 3 different pages open and having to deal with them one at a time. You can do it all in one go, and it will draft 3 emails all at once for you. So that's the second stage. You can skip that stage completely if you refer to client and then respond in full. So if you refer everything to your client that you need to, and you go away to third parties and get what you need, and then refer in one go, you can do. It is designed by conveyancers. So it is designed by conveyancers. I'm an ex-conveyancer. We have Alison, who is our lead conveyancer here, and she's been head of conveyancing at multiple different places. We also have Marion Palman, who owned her own business. She owned her own law firm for many, many years. And Chris Harris, again, who is a solicitor. So we have us. We also have user groups that we've got trials of at the moment. We've got 20 firms currently using, and they are giving us feedback constantly. And we are developing it around what their suggestions are. That helps. It's nice and easy, as we've said. It is an Outlook add-in. There is also a processor version where you can just forward an email to Inquiry Manager, and it will do exactly the same. It will just do it in a different way. So it will pull it through just by forwarding an email to the email process. And again, security is the biggest part. And that is a big part for us. It is secure. We're currently, again, we'll go through it in a little bit more later on, but we are currently going through our cyber. Well, we've got our cyber essentials. We're looking to get cyber essentials plus, and we're also dealing with legal high quality standards at the moment as well. So that's jumped. So again, where we're at the moment is, if everyone's happy, I can run through a very quick demonstration of the product so you can see it live in action. Take about 5-10 minutes, and then jump to questions, if that's okay with you, Ian.
Thanks, Jamie. Are you surprised with the slides? It's just the next slide in the list. I don't know.
No, it's me. Don't worry, it's me. It's me.
All right, thank you. I thought,
it was me. It was me.
I thought once again.
I thought, have I put another slide in? But no, I didn't. I left it there because I knew
Jamie.
Time.
Jamie, I thought I'd let you down. So
no, you haven't, mate. You haven't.
Go. Okay, lovely. Jamie, thank you so much indeed for your time spent with that. So just so we know, if people want to sort of be on the journey with you with regard to product development, you're still looking for firms to sort of participate in that sort of manufacturing trialing role.
So we're still trialing, so it's still a trial as it stands. We're open to anybody that wants to come and trial the product. What we do say is, for variety purposes, again, we've spoke about workflows. Different people work differently. So if firms do want to come on, we suggest 3 to 4 users come on at once and they can trial it. The trial hasn't got an end date as it stands. We've had trials. We've had people trialing it from the very first iteration, which was in March, up to version 1.2.3 or 1.2.4 as of Monday. And you know, it's going from strength to strength. And every single month we do have user groups where we suggest everything, and we get a lot of the topics that we talk about and how we can make it better for them.
Got you. Jamie, another question. Can I integrate what you've got into case management systems or whatever else I've got? Is that possible? Is that part
as it stands at the minute,
ethos?
we are talking to some case management systems. We are looking to integrate with them.
Yeah.
Integration is on our priority list. We do want to integrate.
Mm-hmm.
It will already kind of, if you have an auto save function inside of your case management system through Outlook, it will have a slight integration from there.
Right.
We do also have reports that you can download, and it will give you a very comprehensive report of exactly where you're at in terms of your inquiries, time stamped to each one, which you can save as a PDF straight into the case management system. So as it stands at the minute, we don't have any integration with them. We have got quite detailed conversations happening, and we're hoping that they will come round very, very shortly. But as it stands right this second, we're trying to do everything we can to make it as simple without having integration.
Got you. Jamie, thank you so much for your time. Give my regards to Mr. Harris and tell him that next time I look forward to hearing from him, and hope he's safe and well. What I want to do now is sort of go back to the sort of main ethos of today to look at some issues. Jamie, I'm going to go through some questions in the chat. If there is anything that's related to you, can I call you back up to?
I'll stay in the call. I'll stay in the
Brilliant. Thank you. That's great. Anyway, so look at some questions. While Jamie was doing that presentation, I was monitoring the chat, and I've got a question from, I hope I'll say this right, Anup. Can anyone tell me what the position is when a client is buying a high-risk leasehold building with 8 floors, where the lease was extended in 2023, meaning the lease was granted after the 15th of February 2022. It's the 14th of February 2022, which is the key date. Am I right that leaseholder and landlord certificates are not necessary? And what advice should I give a client on probably not being one that falls into the BSA? And Zara sort of takes up the issue and says, yeah, you're right. Can I just look at this? And first of all, can I show you a case? Do have a look at this case called Lena against Land Street Management Company Limited. It's a lower tribunal decision, I think. It might be upper tribunal, but really useful in that the tribunal has attempted to take you through what you need to do in dealing with relevant buildings. Now, some people think that the tribunal has looked at the book that we wrote for the Law Society on the BSA, because our sort of checklists and flowcharts idea seems to have been taken up by the court. And perhaps that's wishful thinking on our part, but it's a really useful decision that shows the practical side of Schedule 8 of the Building Safety Act. If anyone wants a copy of a case law report that I've done on it, drop me a note by email. I'll send it across to you. There was a full report in Property Law UK last month, and I think if anyone has seen it, the case really helps. But to deal with Anup's question, let's just have a look at it, right? First of all, high risk buildings for purposes of Building Safety Act are buildings that are more than 18 metres in height or that carry more than 7 stories and contain 2 residential units. If a building is a high-risk building, 3 things immediately apply. 1, the building must be registered with the Building Safety Regulator. The Building Safety Regulator register is now an open register. You can go on the HSE website and you can actually see if a building is registered as a high-risk building. You can also see documentation that was submitted in support of that application. A higher risk building is, generally speaking, going to also be a relevant building. So the point that Anup makes about leaseholder and landlord certificates, generally speaking, will apply to a higher risk building. However, 2 things. 1, we've got the fact that our lease was extended in 2023, and Anup says, well, therefore, the lease was granted after the 14th of February 2022. So the lease is not a qualifying lease. Of course, a lease extension, whether a statutory lease extension or a negotiated lease extension of a residential long lease, if the existing lease was protected, the extension is also protected. Now, that's not an automatic protection. It's necessary to check what's happened during the lease extension process, but I can give you a degree of comfort to say that the vast majority of standard residential leasehold extensions, if the existing lease was a qualifying lease, the extended lease will be a qualifying lease as well. But Anna rates a really interesting point. If the freehold to the building is owned by leaseholders, then the building is not a relevant building, and that's correct. Now, there's some debate about what we mean by leaseholder owned. Does it have to be owned by the leaseholders, in other words, more than one? Or if one leaseholder owns the freehold to the building, is the building automatically excluded from being a relevant building? Well, the regulations and the Act don't make it clear. The safe position seems to be that if one leaseholder owns the freehold to what would otherwise be a relevant building, the building cannot be a relevant building. I know of two groups of leaseholders who are up in arms about this, thinking this is grossly unfair. 100 flats in a block, 99 leaseholders, all potentially owning qualifying leases, but one of our leaseholders owns the freehold. We can't be a relevant building. One of the groups of leaseholders is wanting to take the matter to first-tier tribunal to argue that that can't be the position. That is completely and utterly against the spirit of the Act. You then got to say to yourself, well, all right, we're not a relevant building, but could we be a higher risk building? Well, the answer is yes, we are a higher risk building, provided the building contains 2 or more residential units and provided we meet the height criteria. That means, 1, all residential long leases in that building have terms implied into them, courtesy of the Building Safety Act, which amends Section 20 of the Landlord and Tenant Act 1985. That imposes obligations on the building owner, the landlord, and imposes obligations on leaseholders within the building to comply with building safety risk controls and measures that the landlord introduces, which requires leaseholders to allow landlords to inspect their property for building safety purposes, which imposes a whole raft of additional burdens on landlords, which will mean that the service charge cost for residential leaseholders within higher risk buildings will increase. So hopefully that deals with that question, Anna. Zara's right with what she says in connection with her response as well. What I always say to people, and this applies in residential leaseholds generally, your client is committing contractually to pay a service charge, which is an unascertained and unascertainable future expense. Where the building becomes a higher risk building or is a higher risk building, the obligations with regard to service charge are probably more onerous in that the service charge is likely to be higher than in a building that isn't a higher risk building. The other important thing to understand and appreciate is that you may have a building currently that isn't a relevant building, nor is it a higher risk building because it's, say, 4 stories in height and say it's less than 11 meters in height, or it contains less than 2 residential units. Do be alive to the fact that the owner of that building could undertake an airspace development or a refurbishment of the building that then means it increases in height and becomes a relevant building or a higher risk building, or the building now has more than 2 residential units within it and therefore is a relevant building or a higher risk building as a consequence, in which case, if the building is a relevant building, existing leaseholders within that building are then protected by Schedule 8 of the Building Safety Act 2022, which means that any leaseholder in that building, commercial or residential, qualifying leaseholder or non-qualifying leaseholder, is protected because the landlord can't include within service charge remediation costs for relevant defects that arise as a consequence of work that the landlord or an associate of the landlord did. So where we've got a building that currently isn't a relevant building, but is developed or refurbed so it becomes a relevant building, existing leaseholders within that building are likely to be given some protection by Schedule 8, the Part 2 protection that I've just mentioned. If the leases were qualifying leases, then they get the greater protection that Schedule 8 of the Building Safety Act applies. So to an extent, an existing leaseholder in a building that becomes a relevant building is better protected than beforehand. If you are acting for a leaseholder who's acquiring a new lease in that building because of airspace development, then the Schedule 8 protection will not apply because of the point that Anup mentioned and Zara mentioned about the fact that these leases are granted after the 14th of February 2022. Where the building becomes a higher risk building, then all leaseholders now have terms implied into their residential long leases, and all are vulnerable to an increase in service charge because of the status of the building as a higher risk building. The problem with relevant buildings is that it can be difficult to ascertain height or number of stories. The beauty of a higher risk building is the building has to be registered as a higher risk building, and therefore we can assume with the degree of safety that the building meets the height criteria or number of stories. A word of caution, a building could be registered as a higher risk building but in error, and therefore at some point in the future it's identified that it is not in fact a higher risk building due to the height or number of stories. And therefore when you are advising a buyer, I would always say to a buyer client, I'm going to assume this is a higher risk building because it's been registered as such, but I can't guarantee that's the case because I, as a conveyancer, have not undertaken any form of check or investigation to verify that point. Exactly the same principle would apply in connection with a relevant building. So great question, Anup, and great response, Zara. Thanks for that. Let's have a look at Sam. Quick question. Leasehold and Freehold Reform Act 22 prevents the granting of new leases, but does it prevent the assignment of an already existing leasehold property? I don't think it does prevent an assignment, in that I don't think it's retrospective. But what I'm going to do is I'm going to have a look at that and come back to you, Sam, if I can. So I'm just going to take a photograph of that. And Claire, if you can make sure we've got a copy of that chat question, I'm going to go scurrying off after today and have a look at it. But I'm fairly confident it's not sort of retrospective in that regard, Sam, but I'm going to check it. Anup comes back. Should I advise the client may be difficult to sell the flat in the future, given it's not protected by the BSA? There's a number of things that arise from that question, Anup. First point, whenever you're advising about is it a relevant building, is it a higher risk building, I would always warn a client that, you know, I'm reliant on third parties to tell me about height or stories, and it might be that in some point in the future what we've been told or what we've assumed is in fact unsafe. Where that is the case, we may be buying a property where we think the property has the protection afforded by Schedule 8 of the Building Safety Act, but we can't be sure. Where the property definitively is not protected by Schedule 8, I think you warn the client that when it comes to marketability in the future, or the use of the property as security for mortgages, the fact that the lease is not qualifying might cause us problems. There's another thing that I think is important before I leave this issue, and that concerns some work that I've been doing recently. And it concerns the situation where we have a relevant building and a landlord requests from a leaseholder deed of certificate. You'll remember that a landlord can do that when a leaseholder notifies the landlord of their intention to sell. So I'm a landlord, that can immediately trigger me requesting a leaseholder deed of certificate from the leaseholder. The Act and the regulations make it quite clear that I make the request, and I think I've got to do so within 5 days of notification, and then I'm required to send a series of warnings or reminders to the leaseholder. I haven't got your leaseholder deed of certificate. You need to produce it in 8 weeks. You can extend that time to a period of 12 weeks by making a request. The Act refers and the regulations refer to prescribed steps and reasonable steps to obtain a leaseholder deed of certificate, including situations such as where the landlord is talking to the leaseholder about another matter. The landlord is required to highlight the fact, I'm still waiting for a leaseholder deed of certificate from you. So all of this obligation on a landlord to send reminders, etc., sort of suggests that it's important that a leaseholder complies with the time limit. And the assumption was that if you fail to comply with the time limit for the production of a leaseholder deed of certificate, the lease was deemed to be non-qualifying. If you now look, I've had from 3 different sort of sources the fact that that isn't correct. The lease is deemed or assumed to be non-qualifying until a leaseholder serves a leaseholder deed of certificate that states the position is to the contrary. So my understanding of the Act and the regulations were leaseholder asked to produce a leaseholder deed of certificate, landlord waits 12 weeks. If the landlord does not get a leaseholder deed of certificate, landlord can state that lease is non-qualifying. That's wrong. The landlord can assume the lease is non-qualifying until a leaseholder serves on the landlord a leaseholder deed of certificate that states the lease is qualifying. So I can't scupper a leaseholder from holding a qualifying lease by demanding a leaseholder deed of certificate and hoping the 12 weeks expires without its production. All I can do, and the only sort of benefit I've got from making the request, is during the period until I get a leaseholder deed of certificate stating the lease is a qualifying lease, the lease is assumed to be non-qualifying, and I can ask or demand from that leaseholder service charge for remediation work for relevant defects. And the leaseholder would hold a non-qualifying lease in those circumstances. But the moment a leaseholder is properly advised in those circumstances, it serves on me a leaseholder deed of certificate. If the leaseholder deed of certificate states the lease is qualifying, then the Schedule 8 protections for that leaseholder apply. I hope that makes sense. Leah asks a question. Well, first of all, Zara, Jamie, flexibility to mark up the inquiries before you send them to the selling client to answer. A lot of it will need explanation to the lay person. Zara, I can deal with this, and Jamie, you're more than welcome to interject too. But yeah, the problem with the TA forms is just what your role is with regard to providing explanation. And that's been one of the problems with regard to the revised TA6, and the fact that the additional questions impose additional burdens on leaseholders, sorry, on sellers, and also imposes additional burden on the conveyancers acting for the sellers. Jamie, do you want to step in there?
Yeah, I think it was something we were speaking about yesterday, and I think it's something that I'll tread lightly on because I know that it's difficult, really. And I think there's going to be many different views, as we've seen yesterday. And I think you are right. I think there is a lot of explanation there that's needed. From how we're looking at it, we're always looking at it from the point of view that the client will, necessarily know limited amounts. There's a reason why they pay us as conveyancers to do a job, and that is certainly to help them understand. I used to have clients that didn't understand what inquiries were. When you told them that they were just questions for the property, they got it straight away. Something from a personal standpoint that I can say is, when I was training conveyancers, I would always say, speak to a client like you would your mum when you're having a cup of coffee. Speak to the client how you would your friend in a pub. You wouldn't be very happy, would you, if you went round to your friend's house who's an electrician and he sat there talking in electrician language to you about your electrics. You'd go, I have no idea what that meant. Could you say that again for me? So I do agree with the fact that there is a lot of explanation around it. I do also think that there is ways and means around it. And I think I think it's a case-by-case basis. I think we have to work out what they know on a case-by-case basis, is what I would say.
Thanks for that, Jamie. Jamie, all of that assumes you've got friends. I'm in
I know,
an unfortunate position that I have a number of acquaintances.
I hope so.
And
if not, I'll be your friend.
People that I think are friends, but the reality is that they dodge me, which is fair enough. But anyway, we'll move on from that. Leah makes the question. Hi, Leah. What's the position where a new lease is being granted for a new flat on a... Leah, this is something I've been working on a lot with some friends at Tom and Snell and Passmore about airspace development. I think the first point, Leah, is if you're acting for someone who's in a property that isn't buying a property in a building that isn't a relevant building or a higher risk building, tell them there's always a risk that airspace development takes place. I've did a lot of work looking at case law as to how leaseholders can block landlords from carrying out airspace development. And in short, there's not much you can do unless the lease precludes the landlord carrying out airspace development, which would be highly unusual. So, Leah, to answer your question, if there is an airspace development, your client is buying a flat on, say, floor 16, there is no way that that new lease is going to be a qualifying lease for the purposes of a relevant building, okay? The thinking behind the Building Safety Act is that if this is a refurb or a new build, the building, the construction, the works that are done will be compliant with current building regs. That means there shouldn't be fire risks or other building safety risks. So in those circumstances, you're not going to get any of the protection that a leaseholder in a relevant building would have, other than, and again I repeat the point, Part 2 of Schedule 8 says a landlord cannot transmit remediation costs for relevant defects that arose in connection with works which were the responsibility of the landlord or an associate of the landlord. Where the landlord instructs a contractor to do the works aren't done by the landlord. And when we talk about an associate, we're talking about an entity with a close connection to the landlord. But the important point here is, one, the client shouldn't be that exposed, given what you said about building control. But if the building is a higher risk building, all that I've said about terms being implied into the lease and the risk of additional service charge costs arising as a consequence of the status of the building apply. So hopefully that makes sense, Leah, and hopefully that answers the question. The last question that you raise, what is the difference if the shares in the freehold company are owned by the leaseholders? Well, then the position is that the property is leaseholder owned. It doesn't have to be owned by them as individuals. There could be a vehicle that they own that owns the building. The only thing I would say here is if the leaseholders apply for a right to manage or something of that nature, that wouldn't generate leasehold ownership. Okay, right. Karia. Hi, Karia. What steps, if any, should an executors be taking to enable them to answer the questions in the leaseholder certificate, particularly only or principal home, when the estate has more than one? Right. Okay, let's look at this. Great question. First of all, if you're acting for executors, the proposition seems to be that the executor can complete a leaseholder deed of certificate on behalf of the estate or on behalf of the deceased. The problem is, and the issue is, what would the executor's knowledge be in connection with the deceased? Because you're talking about not just proof of ownership, but the state of mind of the deceased as to whether this was their only or principal home as of the 14th of February 2022. There are two schools of thought. The first school of thought, which I think is a bit irrational, is that the executor completes a leaseholder deed of certificate explaining their status as of the 14th of February 2022. I don't think that can be right. I think that all the executor can do is assess and investigate the status of the deceased as of the 14th of February 2022. And all you can do is advise the executor, look, if you get this wrong, and as a consequence of what you say in the leaseholder deed of certificate, this lease is a qualifying lease, and at some point in the future it's identified that the deceased did not treat this as their only or principal home as of the 14th of February 2022. The leaseholder deed of certificate becomes void, as it were, and the lease by default becomes non-qualifying. That could potentially lead to a misrepresentation claim being brought against the executor who completed the leaseholder deed of certificate. So I think you need to step warily, Karia, with regard to that, okay? I'd be warning an executor, look, you're confirming the status of the deceased as of the 14th of February 2022. The answers to the questions or the completion of the leaseholder deed of certificate could have fairly serious consequences for you if you get it wrong. I think you need to cover your firm's back by saying we're not going to accept any liability because we have no knowledge of the status of the deceased as of the 14th of February 2022. And we're warning you that if what you say is incorrect, there is the potential for a claim being brought against you by the buyer or indeed subsequent owners. Zara, I'm not going to get you started on the new TA6 form, so never mind an exclamation mark, you're safe. However, did anyone listen to the law programme on Radio 4 on, was it Tuesday night? Very interesting, brief conversation about Japanese knotweed and about a case in Edinburgh involving a disclosure by the seller of a property in Edinburgh that they were not aware of any infestation, and the property was burdened by Japanese knotweed, which the sellers were aware of. And the court has determined that Japanese knotweed constitutes an infestation, meaning that the seller is liable to the buyer. The evidence before the court seems to be that the seller is liable. And on that report in the law programme, a surveyor was saying that where a property is burdened by Japanese knotweed, he estimated that the diminution in value of the property was approximately £60,000. The TA6 form, as is, requires the seller to disclose the existence of Japanese knotweed in the property or within 3 meters of the boundary of the property. No seller can possibly know or can say truthfully, without fear of liability, that there isn't any Japanese knotweed in their property, and they certainly can't say there isn't any Japanese knotweed within 3 meters of our property. Sam asks, what made them change their mind about the 24th of June? Zara and her colleagues, Sam, were concerned about the position, and as Zara mentions, a vote of no confidence in the Law Society brought by the Property Lawyers Action Group, I think, got the Law Society to revisit. Note it's been postponed. Note that hopefully that will mean there'll be consultation with the profession and also consultation with other professional bodies. Zara's right. They're saying that you can still use the new TA6. I think Zara's put a hand up, so if we can allow Zara access via her microphone, that would be fine. Can we do that, please? Zara, fire away if you can. I don't know whether we're able to allow her access or not. Hopefully we can. You don't have to use it. What I would say is, hi Zara, go on. Yeah, hi Zara, go on. Yeah, carry on.
So basically, very heated debate yesterday. I can send you a summary.
Thank you.
You know, the Law Society are banging on about how useful it is, and they're basically aiming for the nirvana of the perfect contract pack, which we all know doesn't exist.
Yeah.
But what's become clear is that national trading standards are not going to enforce the guidance against the estate agents.
Yeah.
What they're doing instead is relying on the portals to do that.
Yeah.
But also it's a backhanded way of getting solicitors to police the estate agents.
Yeah.
I raised the point of criminal liability, of which they had no understanding or weren't able to answer.
Yeah.
They said they'd had counsel's advice but had brushed it off.
Yeah.
I'm actually saying there's, you know, there is a potential, but other people in the room were basically saying it's just an opportunity for more work to go to the factory outfits because of referral fees. And some people are saying that they've already used it, it's caused delays, it's not working.
Yeah.
Some agents have been asked about it and they don't know about it.
Yeah, seen that. Yeah,
so
it's a mess, isn't it?
Whatever they're trying to do, it's not working.
Yeah,
but
I'd agree.
I'll tell you about that another time, Ian.
Yeah, thanks for that, Zara. There's a few things that Zara mentioned there. Firstly, criminal liability as a consequence of breach of regulations, the consumer regulations, but also the potential for criminal liability where a client makes a deliberate lie with regard to an answer in the TA form. Zara mentions criminal liability. She's concerned, as I am, about criminal liability for the lawyer that is acting for the seller where information in the revised TA6 is defective. That would potentially lead to a breach of the consumer code that has the potential for criminality arising. The thing I'm worried about in connection with the new TA6 is as follows. One, just about double the questions that were asked in the old TA6, some repetition in connection with leasehold inquiries, reference to the client being told to seek third-party guidance in connection with some of the questions and some of the replies, and also seeking guidance from the solicitor or conveyancer that's acted for them. Now, that runs completely against the spirit of the TA forms and the guidance within the forms that the seller client completes the forms without advice or guidance from a conveyancer. There's a legal point as well that Rosser and Pacifico, William Sindel PLC against Cambridgeshire County Council both say that if you're answering a question, you should make reasonable inquiries before answering it to determine that what you're saying is correct. Well, what are reasonable inquiries? If the forms themselves are saying speak to your solicitor or check with the coal authority website or whatever, and you don't do that, then have you behaved unreasonably and have you generated potential liability as a consequence? Yeah, and I think it's really dangerous. Sue, if you look at the case of Rosser and Pacifico, the judge said in that case, interestingly, that the conveyancing process requires the seller to provide information for the buyer because the seller knows more about the property than the buyer. And I'm thinking, well, yeah, that's right, but caveat emptor no longer applies in those circumstances. So that causes me a problem. Yeah, it's all about consumer protection. Well, I get that. But the point there, Zara, is if you're asking questions and if a seller's terrified about providing a meaningful response and just says, I don't know, how does that benefit the consumer buyer? You know, surely any seller reasonably advised or knowing a little bit about the potential for misrepresentation and other points is going to be very wary about what they say in answering questions. And if you're their lawyer, having read Rosser and Pacifico and other cases, you're going to be saying to the client, be very careful about what you do. Otherwise, you could potentially be sued for misrepresentation for some significant sums. And of course, you're going to be liable for legal costs and all that goes with it. Yeah, Rosser and Pacifico, Zara, the judge said that because the seller was arguing, look, the buyer had instructed a solicitor. The buyer should have checked the planning status of this building. The buyer should have checked that building regs had been complied with. Okay, and therefore the fact that the seller made a mistake in the TA forms should be of no consequence. The judge wouldn't have any of that, and he said no. The TA forms and the seller completing the TA forms is an important part of the conveyancing process. The seller knows more about the property than the buyer. As part of the conveyancing process, the seller should be sharing their knowledge with the buyer to enable the buyer to make the decision whether they want to proceed or not. That's the point that I'm making there, Zara. And the other point in Rosser and Pacifico is the judge said if you're answering a TA form to say you're not aware of breaches of building regs, you need to check that in fact is true before you answer the question. That's pretty scary stuff, isn't it? And I think another thing that I was reading in a case about the old TA forms was that the judge said where you have a wide-ranging answer, a seller should produce a wide-ranging response. So if you're just asked about the existence of Japanese knotweed in your property, then that's all you answer. If the question asks you about Japanese knotweed in your property and other property adjoining it, then that becomes far more wide-ranging and warrants far more wide-ranging investigation before the answer is provided. So to be honest, to sum up with regard to the TA forms, when I promised Zara I wouldn't talk about the TA forms, there's a mountain of work that needs to be done with regard to changing the ethos of the seller with regard to replies in the TA forms, clarifying the role of the conveyancer in assisting the seller with regard to the provision of information so the seller can answer the questions in the TA forms. And you've now got, of course, the need to advise buyers about the potential for misrepresentation, the potential for that misrepresentation being actionable, along with a health warning to say you might in law be entitled to bring a claim against the seller, but you may not have an appetite to incur all the legal costs and incur all the time in pursuing such a claim. Okay, I'm going to skip that now and just have a look, because there were some questions that I wanted to talk about. The BSA update we've covered. Check what you're saying to clients about where a seller hasn't produced the leaseholder deed of certificate where the landlord has asked for it, because it now seems that the buyer could issue a leaseholder deed of certificate, serve it on the landlord, and if that certificate confirms the lease is a qualifying lease, the lease that was non-qualifying or assumed to be non-qualifying due to seller default all of a sudden becomes a qualifying lease. Rural properties and agricultural searches, have a look at the Agricultural Law Association website and do have a look at your search provider and have a look at agricultural searches in rural properties. I'm dealing with a matter at the moment where a client bought a property in a rural area with forestry alongside it, wasn't aware that timber extraction licenses had been granted. So what was a sort of woodland idyll all of a sudden is going to be an industrial site whilst the vehicles and traffic goes in to clear the woods, and then becomes sort of scrubland until the area is replanted, which, you know, that's going to take 10, 15, 20 years before the trees become sufficiently established and the environment becomes what it was, as it were. BSA update we've covered. Indemnity covenants in residential transactions. Christopher raised a point about indemnity covenants in residential transactions, and I want to just look at this. The relevant standard condition in the standard conditions of sale is 464. And what it states is, and I'll read it, if after completion the seller will remain bound by any obligation affecting the property which was disclosed to the buyer before the contract was made, but the law doesn't imply any covenant by the buyer to indemnify the seller against liability for future breaches of it, the buyer is to covenant in the transfer to indemnify the seller against liability for any future breach of the obligation and to perform it from then on, and, if required by the seller, the buyer is to execute and deliver to the seller on completion a duplicate transfer prepared by the buyer. So the point here is, if there is an indemnity that's implied in connection with the covenant, then there's not necessary for an indemnity covenant to be provided. But if that isn't the case, and there is an obligation affecting the property disclosed before contract, an indemnity covenant is required. Now, I think Christopher was touching on the point. What happens if you know that there's been a break in the chain of indemnity covenants? Well, in those circumstances, would that constitute an obligation affecting the property? My view is it wouldn't. What does everybody else think? Are you seeing people still insisting on indemnity covenants in transfers? And do you think people appreciate when an indemnity covenant is required and when it isn't? Anybody? Just have a quick look in the chat and see what people have to say about that. Yeah, people still are insisting on indemnity covenants. Are they doing so, Zara, even if there's evidence of a break in the chain of indemnity covenants? The point I would make is, how are you going to know there's a break in the chain of indemnity covenants? But I think, yeah, people still are insisting on it, but do be aware of 464 of the standard conditions of sale. Yeah. Anyone got any further questions, any issues that we need to explore? I'm conscious of time. What I'd like to do is to thank Jamie from Collaborative Conveyancing, to thank Robert and Jenny and her colleagues from Stewart Title for attending today. It's really kind, and thank you all. I hope it's been useful. Have a look at that case on the Building Safety Act. It's a really important case that does provide some really practical guidance. Just want to say, make sure you're saying as it is a higher. Yeah. I'll make that up. If a building is a higher risk building, then Part 4 of the Building Safety Act applies to it, whether it's leaseholder owned or not. The whole idea of Part 4 of the Building Safety Act is this is a higher risk building and leaseholders need additional protection as a consequence. The leaseholder owned and the exempt status of the building applies to Schedule 8 of the Building Safety Act, which is dealt with in Part 5 of the Act. And if you want to drop me a note, send me an email and I'll explain that a little further if need be at my email address. In the interim, I'm going to finish. And thanks, Stewart Title. Thank you, Jamie. Thanks, everyone else, for coming along today. Yeah, it's really interesting stuff, isn't there? I'm going to have a look at the Freehold and Leasehold Reform Act, and perhaps we can have a little session on that next time we're together. Okay, email address shown, IQ sorry, I've got it wrong there. It's iqlegaltraining.com. Anup. I'll put it in again. Sorry about that. More haste makes less speed, doesn't it? And Jenny, our Canadian correspondent, yes, look forward to seeing you in a couple of weeks' time. That would be lovely. Brilliant, everyone. Thanks very much. Stay safe. Speak soon. Thank you. Bye-bye.